thought it couldn't get any worse for Big U. New paperwork has just come out that pretty much states that the feds have 20,000 wiretapped phone calls that they intend to use during the course of Big U's trial, along with an additional 60 gigabytes of evidence. Now, that is a lot of evidence, y'all. So we are going to get into the paperwork and see what all the government says. But to play catch up for just a quick second, Big U's trial was set to start on May the 9th, which is quite literally less than a week away. Right now, Big U has the right to a speedy trial. He has the right to request that the government hurry up and give him his sentence since they have already arrested him. And believe it or not, Big U wants the trial to start on May the 9th. However, his co-defendants do not. So the first piece of paperwork, and this is short paperwork right here that I want to get into, is this proposed order to continue the trial date. They want to push it back to May the 4th of 2026, which is about a year away. And when I say they, I mean a lot of Big U's co-defendants and the federal government want this to happen. So in this proposed order for continuing trial, the judge actually does approve the continuance, but the only defendants' names that I see listed in this continuance are Robinson, Martin, this chick, Blanton, and Hines. And all of these people are pretty much out on bond right now, everybody except for Big U and Loose Cannon. And while Big U has objected to it, all of his co-defendants have agreed to it. The judge has granted it, and there was no motion for severance that was granted. So it does look like Big U is going to be tried in 2026 along with the rest of his co-defendants. The reason why they wanted to push this back is because apparently the prosecutors in this case have a bunch of trials that are happening during this period. Some of the co-defendants' attorneys have trials happening in this period, including Big U's attorney, who has a big trial starting the day before it starts. All of these are reasonably reasonable reasons why the trial would be pushed back, right? So with that laid out and with this document right here pretty much covered, let's go ahead and get into this new pleading where the government says that they have 20,000 wiretapped phone calls against Big U. So here's the paperwork. This is a stipulation regarding request for continuation of trial date and findings of excludable time periods pursuant to the Speedy Trial Act. And so the document says plaintiff, United States of America, by and through its counsel of records, and defendants Sylvester Robinson, Mark Martin, Tremaine Williams, Armani Elefe, Frederick Blanton Jr., and Tiffany Shanika Hines, all individually and by and through their counsels of records, respectfully hereby stipulate as follows. The indictment in this case was filed on March 26, 2025. Defendants Robinson, Martin, this chick Blanton, and Hines first appeared before a judicial officer of the court in which the charges in this case were pending on March 19, 2025. The Speedy Trial Act originally required that the trial commence on or before June 4, 2025 as to those defendants. Defendant Henley first appeared before judicial officer of the court in which the charges in this case were pending on March 20th, 2025, and the Speedy Trial Act thus originally required that the trial commence on or before June 4, 2025 as to that defendant. Defendant Williams, this is Loose Cannon, first appeared before a judicial officer of the court in which the charges in this case were pending on April 4th, 2025. The Speedy Trial Act thus originally required that the trial commence on or before June 13th, 2025. On April 4th, 2025, the court set a trial date of March 19th, 2025, and a pretrial conference of May 9th, 2025 as to the defendant Loose Cannon. On April 18th and 14th, 2025, the court set a trial date of May 20th, 2025, and pretrial conference for May 9th for all other defendants. Defendants Henley and Williams are detained pending trial. Henley is Big U, Williams again is Loose Cannon. The remaining defendants are on bond pending trial. The parties estimate that the trial in this matter will last approximately 12 days. By this stipulation, defendants move to continue the trial date to May 4th, 2026, and the pretrial conference date to April 24th, 2026. This is the first request for a continuation. Defendants request the continuance based upon the following facts. Defendants are charged with varying violations of 18 U.S.C. 1962, the Racketeer Influence and Corrupt Organizations Conspiracy Act, and conspiracy to interfere with commerce by robbery and extortion, interference with commerce by robbery and extortion, transportation of an individual in interstate commerce with the intent that that individual engage in prostitution, wire fraud, embezzlement, conversion, and international misapplication of funds from organization receiving federal funds, bank fraud, attempt to evade and defeat the assessment and payment of income tax, willful failure to file a tax return, and the government has produced over 60 gigabytes of discovery to the defense, including law enforcement reports, search warrants and returns, criminal history documents, recordings, and photographs. The government is in the process of producing over 20,000 intercepted audio calls, as well as numerous surreptitious audio and video recordings, much of which will be protected discovery. The government sent defense counsel a stipulation for a protective order. Ayo, 60 gigabytes of discovery is crazy. 20,000 intercepted audio calls is crazy. I don't know if I've made 20,000 phone calls in the entirety of my life. They started investigating Big U in 2021. I'm assuming all 20,000 of these calls came during that time period. Basically, bro was on the phone and couldn't shut up. This is an insane amount of evidence. It continues, it says, while defense counsel for Big U notes that defendant Big U objects to any continuances, defense counsel represents that he is presently scheduled to be in the trials listed in the document attached to this filing as Exhibit A, as well as various other matters. Defense counsel for defendant Robinson is presently scheduled to be in the below described trials, as well as various other matters. And then they list out all of the trials that Robinson's attorney is going to be involved in. I think Big U's attorney is going to be involved in some of these too, right? And the reason they're laying these out is to say, hey, look, we're busy. We're not going to be able to do this trial at this time. We have other cases that we are working on. And so that goes on for a few pages, right? I'm not going to read every case that they're going to be involved in because it's just a bunch of details that have nothing to do with Big U or with the rolling 60s. So it says, accordingly, counsel represents that they will not have the time that they believe is necessary to prepare and be available to try this case on the current trial date. In light of the foregoing, counsel for defendants also represent that additional time is necessary to confer with defendants, conduct and complete an independent investigation of the case, and complete additional legal research, including for potential pretrial motions, review the discovery and potential evidence in the case, and prepare for the trial in the event that a pretrial resolution does not occur. Defense counsel represents that the failure to grant the continuance would deny them reasonable time necessary for effective preparation, taking into account the exercise of due diligence. Right? So basically they're saying all the defendants agree that even though they have the right to a speedy trial and it should start in May, the lawyers need time to prepare, time that they just don't have. So all of the defendants and the feds are requesting a continuance. But in K here it says defendant Big U objects to continuing the trial in this matter. So he don't want it to be continued till next year. He's basically like, bro, y'all denied me bond, y'all arrested me, y'all got me in here. Either y'all got the evidence or y'all don't got the evidence. Put me on trial. I don't care if my attorney is prepared or not, which is crazy because Big U is facing 600 years. You would think that he wants his attorney to be as prepared as possible, but apparently not. It says, nonetheless, the stipulating parties agree that pursuant to USC 3161, the time period of May 20th, 2025 to May 4th, 2026 constitutes a reasonable period of delay for defendant Big U, who is joined for trial with the co-defendant, as to whom the time for trial has not run and no motion for severance has been granted. The other defendants, however, believe that failure to grant the continuance will deny them continuity of counsel and adequate representation. The government does not object to a continuance. The requested continuance is not based on congestion of the court's calendar, lack of diligent preparation on part of the attorneys for the government or for the defense, or failure on the part of the attorney for the government to obtain available witnesses. So they're saying that they have all that. This continuation isn't because of any of that. It's simply because the attorneys feel like they wouldn't be able to represent their clients to their fullest ability if they go to trial on May 9th. It says, for purposes of computing the date under the Speedy Trial Act by which defendant's trial must commence, the parties agree that the time period of May 20th, 2025 to May 4th, 2026 inclusive should be excluded pursuant to 18 USC. So basically they're saying that you take that year, cut it out. It's like it never happened. Everybody except Big U is agreeing that that delay is necessary. It says, because the delay results from a continuance granted by the courts at the defendant's request without government objection on the basis of the court's finding that the ends of justice served by continuance outweigh the best interest of the public and defendants in a speedy trial, and two, failure to grant the continuance would likely make a continuation of the proceedings impossible or result in the miscarriage of justice. And 3, failure to grant the continuance would unreasonably deny defendants continuity of counsel and would deny defense counsel the reasonable time necessary for effective preparation, take into account the exercise of due diligence. Nothing in this stipulation shall preclude a finding that other provisions of the Speedy Trial Act dictate that additional time periods be excluded from the period within which the trial must commence. Moreover, the same provisions and other provisions of the Speedy Trial Act may in the future authorize the exclusion of additional time periods from the period in which the trial must commence. Basically, they're saying if it is delayed, everybody is agreeing that they are not going to say this violated their right to a speedy trial. This is a very interesting document because we learn about the mountain of evidence that the government apparently has against Big U. 20,000 phone calls, 60 gigabytes of evidence. We learn that Big U is ready to go to trial right now. He don't want to do no waiting, despite all of his other co-defendants saying, bro, if you force this into trial right now, we are not going to get a good defense. Big U was like, I don't care. Y'all arrested me. Y'all unsealed the indictment. Now take me to court. And like I said at the beginning of this video, we did read a document where the judge pretty much accepted this continuance, meaning that Big U will not go to trial until 2026, even though he objected to it because this was a Rico conspiracy case. Everybody's case is tied together. In order for Big U to be separated from the other defendants' trial dates, he would have to be granted a severance, meaning that they separate his case from theirs. The judge did not grant a severance in his response, meaning that it doesn't matter what Big U wanted. He's going to go to trial with the rest of the defendants. This is pretty wild stuff, but for right now, that's what we got. That's the video. Y'all got to let me know what y'all think.